And you would think leases, they're not that complicated. That's just renting, right? It's just an agreement between the landlord and tenant. That's it. Not complicated at all, right? So unfortunately, a lease is a contract and therefore must follow certain rules and regulations. All right, guys, I need to see your faces. If I don't see your faces, you're not here. Okay, shall I please adjust the camera? Randy, if you can adjust a little bit more so I can see you. See what else? Zoraida still in the kitchen cleaning oil. All right, Yolanda, just lower a little bit the camera if you can. Jasmine as well. All right. I got two Chaozus and neither one of them are on camera. This is a problem. Okay. All right. Leases. So when you talk about leases, you talk about renting. Now, real estate professionals should know the local rental market to help buyers who need temporary housing, prefer to rent or cannot afford to buy, or investor buyers, or even to manage their own portfolios. Anyone interested in rental property should understand leases and landlord-tenant issues. So leasing real estate. The lease governs the landlord-tenant relationship. A lease is a contract. It's a contract between the lessor, the landlord, and the lessee, the tenant, right? A lease transfers the lessor's rights to exclusive possession and use of the property. So this creates what? If it transfers the right of possession and use of the property, what does it create? It has to do with rights. We're talking about rights. We have the bundle of rights, but two rights were transferred, and a few more, which I'll talk about in a second, were transferred to the tenant. Okay. When you have the full bundle of rights, what type of tenancy do you have? Nope. That's not what I'm asking. Nope. Nope, not severalty. Having full rights does not give you severalty, in common, joint tenant, or anything like that. That has nothing to do with that. That's the type of ownership. All right, or ownership forms. Because if I'm by myself, I have full rights. If it's me and somebody else, I could have full rights depending on how I own it. Okay, so severalty, in common, or joint tenancy are forms of ownership. We're talking about rights to the property. You're getting close to it, Milton. It's between real property and personal property. You're getting there. Say louder. Freehold estate, full rights. Freehold estate, full rights. If exclusive possession and use of the property were transferred rights, transferred to a tenant, what do we have? Take the free out of it. Leasehold estate. When there's possession and use of the property, now creates a leasehold estate. Word estate because of that possession. Everybody else has an interest in the property. They have an interest. They don't have a right to the property. Okay, benefits and interest. A mortgage company does not have possession of the property. The government does not have possession of the property. Who has possession? Either the owners or the tenants. You got it? So these two have less than, the tenants have less than freehold, if you guys remember, because they don't have the full rights. Which rights are not transferred to the tenant? The right of exclusion is because I can stop you from coming in my house as a tenant. Don't go by what it says here. I'm tricking you.
Can you ask the question?
Yeah, I'll ask the question differently. What are the, let's stop right there. What are the rights, the bundle of rights? Disposition, enjoyment, control, exclusion, She's going over to the seven. And possession, very good. So out of these, which one is not transferred to the tenant? Which one is not transferred to the tenant? All right, I'm gonna go with Emily's answer and kind of Elizabeth and Katie as well, which is the right of disposition or transfer. Can we transfer to somebody else? We're gonna talk about assignment and subleasing, but that's not transferring the ownership or selling the property or gifting the property. We don't have that right. You got it? That's not transferred, right? Now, can we encumber the property? Can we put a mortgage against the property? Under commercial properties, it's very common that if you have a long-term lease, you can get financing against it as well. All right, but generally we don't. As a special residential, we don't. But the rights are being transferred, right? And this is for a specified time and establishes the rents. All right, let's start kicking people out. Boom. Sergio, sorry, but camera's been off for way too long. Oh, she's back. No. She's here. I know. That was. Now there's just one. But yeah, she was on the phone for a while. No, not even on camera. It's been half an hour, so no, I cannot give you those credits. All right. Yeah, no problem, Steven. Gotcha. All right, so where was I? Now, other rights and obligations of the parties are also set in the agreement. And after the lease term ends, the landlord regains possession through reversionary rights. Do you guys remember these reversionary rights? Say it louder. Going back to the owner, yeah, it's reverting back, correct? Do you guys remember the other rights that exist? There's a reversionary right and the remainder right. Very good. Somebody's been studying. So reversionary is when title comes back to me, or in this case, possession of the property. But what is remainder? It goes to a third party, correct? So remainder, it doesn't revert back to the original one, right? It goes to a third party, somebody we appoint to receive the property instead of me, instead of the original. All right, most states' statute of frauds requires a written lease agreement, if more than a year. A verbal lease can be enforceable, but it's always best to put it in writing. Common sense. Now, leasehold estates, there's 4 different types of leasehold estates. We have estate for years. We have periodic estates. We have estate at will, and we have estate at sufferance. Okay, so let's start with estate for years, usually the most complicated one. When you guys see this, and by the way, estate for years always refers to a lease. Okay, so it's a leasehold estate for years. If you see estate for years without reading, guys, your best opinion. If you see estate for years, what do you think it is? Long time. Indefinite. You read it. You suck. Anybody else? Long term. At least you're honest. Like,
Yeah.
long term, like several years, right? It sucks what I'm about to say, right? But that's wrong. See, the thing is, they should make this a lot easier for us and say, hey, it's a definite estate. not for years. Because in fact, an estate for years, it's for any definite period. In fact, it could be years or even months, weeks, or days. Okay, have you ever been, yeah, I know, it's confusing. Have you ever been to a hotel, an Airbnb, a resort? Have you ever? Okay. You had a check-in and a check-out date, correct? That is an estate for years. You had a check-in, you had a check-out date. That's an estate for years. Okay, the key feature is that you have a check-in, check-out. That's it. When you see estate for years, check in, check out. This is very, very important you remember it. And it sucks. Because the sometimes like you expect to be clear, right? You see for years and you're like, this never ends. Could be for one day. I stayed for years. Ashley says, misleading. I know. This is why I usually start with this one. I focus on it. See, let me ask you something else, because there's a big difference between this one and every other one. If there's a check-in and a check-out date, do I have to call you the last day and say, hey, are we going to renew this? Are you leaving, staying? What's going on here? Do I have to? No, because you have a definite start, you have a definite end. When you check into a hotel, you said, hey, I'm leaving on Sunday at 11. They do call you as a courtesy and say, hey, just a reminder, checkout is at 11 or at 12 or whatever time is set in the agreement, just as a reminder, right? So you got to remember that with this one, there's no need to notify anyone. As its characteristic in all leases, a tenancy for years gives the lessee the right to occupy and use the leased property according to the terms and covenants contained in the lease agreement. A lessee has the right to use the premises for the entire lease term, and that right is unaffected by the original lessor's death or the sale of the property, unless the lease states otherwise. So I want you guys to underline this. Because if I have a 1-year lease and tomorrow you decide to, I just got the 1-year lease and tomorrow you decide to sell the property, does my lease end? The answer is no. I still have the right to remain on the property because I have a 1-year lease. The new owner cannot change any of the terms of the lease. Any. You know how sometimes people buy property and they go like, oh, I'm the new owner, so I'm going to raise you the rent. Like you're paying $800, but today's rent is $2,500. I'm going to raise the rent. They cannot even raise by 1 penny until the lease ends. And once the lease ends, we'll talk about this at the end of this chapter. There's also rent control.
I was gonna ask, is that what rent?
Yeah, well, most states don't have a specific rent control rule. They're very broad, right? I'm going to cover this later on. But they do talk about the rights that you have to reasonable increases, not something unreasonable, right? So it does not change if there's death or sale unless the lease states otherwise. If the original lease provides an option to renew, then no further negotiation is required. The tenant merely exercises the option. All right, periodic estate. So the first one is the definite estate or the estate for years. This one's periodic. What do you think it is? Without reading. Horrible, not really reading. Without reading. I see. So there's this guy, Simon Sinek. I don't know if you guys ever heard of him, but the book in the library on the student portal, the book start with why. It's he's the author. And one of his speeches is about how the human brain does not comprehend negativity. So for instance, if you say, don't think about an elephant, that's what he says. What are you guys thinking about? An elephant. But I just told you don't, right? I said, don't read. Guess what everybody does?
Well, we know this information, then you tell us not to read. We know what's gonna happen.
Don't touch the fire. All right. If it's a periodic estate, it's not a limited time. No, it's term to term. It renews automatically. So a month to month, a week to week, could be day to day, could be year to year. Okay. It automatically renews. I don't have to give you any notification to renew. All right. Guys, today is going to be my final warning because I did say that it starts getting tougher and tougher. I see you guys talking to somebody else in the room constantly, or I see you guys on the phone or doing other stuff. I'm sorry, I'm cutting your wings off. I'm kicking you out. And look, it's not for me, all right? It's for everybody. Okay, if you don't want to be here, just let me know, it's fine. I'll refund you the money. That's my promise right now. Usually I don't do this, but I will give you your money back. Just go home. I mean, you're at home, but that's it. All right, if you don't want to take this serious, I don't want you to be here. My job is to make sure that every single one of you succeeds. You don't want to take it serious? Go. There's other schools that are willing to take your money. And that's how serious I am about this. Okay? I don't care about my success ratings, but I do care about your success. You got it? Is that a deal? Okay, I did ask you. I've been asked every single day and every single, like for 5 years. I've been, no, I'm sorry, almost 7 years. It's like repetitive. It's tough. I'm trying to build something new now. I will give you your money back. If you're not serious about this profession or what you were attempting to do, if you just want to throw money away, go do it at a different school. Got it? Is that a deal or what? Okay. So from now on, your full attention. Okay? And it's the same people over and over and over. It's unbelievable. You're ruined for everybody else. It's the same people over and over, getting off the camera, talking to everybody around, like conversations, like full-blown conversation for like 5 minutes. I got a bunch of timers here, so I know it's 5 minutes. And I give you an option. I let it go. I let it go. I let it go. But it's enough. Okay? And then a year later, you try to do this again. And then 2 years later, you try to do this again. And we go back to the same thing. You know the definition of insanity?
Doing the same thing over and over and expecting different
Doing the same thing
results.
over and over and expecting different results. Okay, I'm serious about what I do. I'm licensed already. I don't even need to be here. But if I'm doing this for you, I expect you to do it for yourself as well. All right? Sorry, this is the Friday stressed out Bruno. That's what you just got right now. This is my promise. I'm going to start kicking people out of this. Okay. And just reach out to me. I'll send you the money back. All right. So periodic estates. Emily wrote, periodic sounds like check in, check out for a period of time. It does. But periodic, it goes from period to period. Like I said, as an example, the month to month. So there's no definite period. So if you have a month to month, do I need to call you and say you want to stay for the following month? No. Automatically, just like your electricity bill. Nobody says, hey, you want lines on or off, right? No, they keep on charging you, keep on going until you say, I had enough, let me switch or let me cancel or whatever. So live in the dark. Such an estate begins as a lease for a definite period, but continues after the expiration of the lease. As long as the lessee continues to pay rent at a regular interval, the lessor accepts it and no one gives notice to terminate the lease. So it continues as long as these happen. This type of leasehold is common with residential properties. To terminate a periodic estate, either the landlord or the tenant must give proper notice. Very important. Very important, the difference between these. A estate for years, I don't have to give you notice because you have that checkout date. It's done, right? A month-to-month lease or a year-to-year lease automatically renews. So eventually, if you want to leave, you must notify the landlord, hey, I'm leaving in 30 days. I'm leaving in 1 week, whatever the agreement might be, right? The contract says, like, oh, 3 months before, 1 month before, depending on the type of lease you have, right? But you have to notify. And the landlord as well. If the landlord needs the space, this is the challenge with the month-to-month for the tenants. If I need the space, you're on the month-to-month, guess what? Hey, Alexis, next month, I need the apartment. Okay, that's it. I just got to give you a notification. That's it. Okay, now, just so you guys know, we're going to talk also about pro-tenant laws. Just so you guys know, even though it says month-to-month, residential tenancy, the tenants are usually protected against that 30-day notice. So usually they put the burden on the landlord to give at least 60 days. Okay, because for the landlord, it's easy. You're just getting out and we'll put somebody else in. But for the tenant, they have to pack everything, they have to move, find a suitable space. Exactly. So usually the laws protect the tenant in that scenario. All right. Now, normally the notice must be given at least one period in advance. For example, to terminate a state from week to week, 1 week's notice is required. To terminate an estate from month to month, 1 month's notice is required. Okay. Now, for an estate from year to year, however, imagine saying, hey, next year I'm leaving. I don't know what's going to happen tomorrow for me next year. If it's a year to year, that notice requirement usually varies anywhere from 2 to 6 months. In the state of New Jersey, so you guys know, it's 90 days. All right. So you got to give 90 days notice, 3 months notice that we're leaving at the end of the 1 year term. Okay. Go ahead.
If he's, I know, if he's a guy, you don't want it 3 months, you don't want it.
Oh, we're going to talk about that too, coming up.
Say, who's coming? The cop or the sheriff?
I'm going to talk about that in a little bit. It's coming up. Fernando's like, well, we gave notice and nobody's leaving. What do we do? Who's going to show up? Is it the cops? Is it the FBI? We send the CIA? What are we doing? Send the Army, Navy SEALs? Somebody got to get these people out, right? All right. We're going to cover that. All right. Estate at will. So the basic estates we have, the basic estates are estate for years and periodic estate. These are the basic foundations of leases. But then we have estate at will and estate at sufferance. Just by reading the titles, estate at will and estate at sufferance. What do you guys think? Just by reading the title, nothing else. What do you guys think? Your opinion. Estate at will. What does at will mean? What is it? At will. Has to do with one of the people in the agreement dies. Not will, like last will and testament. No. At will. Voluntary. Accepted. Choice. Our decision. We agreed, right? At will, there's an agreement, right? What about at sufferance? Think of one as being voluntary agreement and the other one being involuntary. At sufferance, the landlord is suffering. Okay?
So that's what I'm gonna overstate.
Deadbeat tenants, that's not fine. That's could be when the tenant overstays. It could be when the tenant breaches an agreement. Okay. All right, I gave warnings. Another one bites the dust. All right, so where were we? Sorry. At will means I agree to you staying here. At sufferance, we breached the agreement. Either was the payment that you didn't pay, so I'm suffering, or you destroyed the property, or you're a nuisance, like too loud and whatever, so you're breaching the agreements, right? Or the lease ended, or you gave notice and you're still there. You said you were leaving, but you're still here. So that creates at sufferance. Okay. So when somebody's there without the lessor's permission, suffering. Okay. So when a tenant fails to surrender possession or holds over, the tenant is responsible for payment of rent at the existing terms and rate. A lease may contain a holdover clause, right? The name holdover is simple. You're holding possession of the property over the period of time allowed, holdover clause. In which case, the provision will govern the rights of both the landlord and the tenant. If a lease does not contain such a clause, then state law will govern and will typically offer these three options. So usually in the lease we'll have the terms of it, but if it doesn't, state law usually says a landlord can accept the rent offered by the tenant, thereby creating a new tenancy under the conditions of the original lease. It's called a holdover tenancy. If the original lease term was greater than 1 year, generally the new tenancy is limited to 1 year. Now, here's something I gotta talk about. I learned this with my very first property. My very first tenant was a huge headache. I should have quit real estate back then, based on what happened. The person was there for almost a year. She didn't pay for almost 9 months. There for almost a year, didn't pay for almost 9 months. Yes. So, I went to court, of course. Eventually, it was my very first property. I didn't have enough money to back 2005, 4 or 5. I didn't have enough money to pay an attorney. I'm already thinking like all these expenses, my very first tenant. I just made my first mortgage payment, right? I just redid a bunch of stuff in the house. No money. If I pay an attorney now, I'm gonna go bankrupt. I just got the house. So what did I do? I started researching the laws and what did I need to do and this and that. Back then, we did not have Google. Okay. Back then, we had Ask Jeeves. I don't know if you guys remember that. There was a few others like MSN still. They were around, right? But Ask Jeeves was the one. So I went and asked Jeeves.com. Jeeves.com tells me, Bruno, you have to give out this notice to pay or quit, giving them some time to pay or they have to leave, right? Different state laws handle this. In New Jersey, as an example, if it's for non-payment, I don't have to give you any notice. I go straight to court. If you don't pay me, I go straight to court, okay? Unfortunately, Jeeves gave me some, what was it, Virginia law or something like that? Gave me Virginia law. Virginia law, you have to give 10 days notice at least before you can go to court. So I sent out the letter to the tenant. Tenant is like, okay, I got a letter. That means we're not in court. If we're not in court, what do I do? Absolutely nothing. The tenant was a professional renter. In case you guys don't know what this is, professional renter are people that know the real estate laws when it comes to leasing, when it comes to renting. They know this stuff. So I finally went to court. I finally paid an attorney. Well, I started on my own, but then finally paid an attorney to go to court. We go to court. This person shows up and goes like, but Your Honor, I gave him some money. She didn't pay me the full rent, but gave me half the rent. And then another 2 or 3 months without paying. But give me half the rent. If I accept the rent, it created a new tenancy. So what happened was, Bruno, did you accept money from the tenant? I said, Your Honor, I did, but I got a mortgage and this and that. I whatever I could. Well, that means you entered an agreement with your tenant to accept the rent in other terms. Come back when the situation changes. Denied. Just like that. I needed to start a whole new case, even though there was already 2 months from when I got the half rent. It was already 2 months. I had to start a brand new case from that half month and on. All right, state laws.
When?
Oh, eventually I was able to get her out, and get the sheriff to go there and everything. But
Got paid for like all that.
no. Oh, that's another thing. Eviction and recovery of money is two separate things. Eviction is to take somebody out. I will go over that as well. Take somebody out of the property. It's a dispossessed proceeding. Money recovery, small claims court. At the time, I did not know that either. She owes me like over $9,000, right? And I'm like waiting. Eventually, I went to the attorney. I'm like, hey, I'm still waiting on the 9,000. Oh no, see what you got was an eviction. I'm like, so I paid you almost $700 just to kick somebody out? I could have paid $50 for somebody on the street to do that for me. You know what I'm saying? And he goes like, yeah, unfortunately, it's two separate cases. So I paid you $700 to advise me, and you didn't advise me on a separate case? Well, Bruno, I'm sorry. And this is a friend of mine, by the way. The lawyer was a friend of mine. We're acquaintances, and I never use this services again, ever. Now I have an attorney that specializes in landlord-tenant cases. That's all he does. And half the price and better advice. Even rhymes. Nice. So it's very, very, very important you guys know these laws, especially if not only for you, if not for you as an individual, but for your clients, obviously, when somebody comes for advice, because you're not going to sell a multifamily property to someone and not talk to them ever again, right? You want repeat business, you want referrals, you want to make sure that they got what they wanted. So you need to know this stuff. So when a month later, somebody calls me up and says, Bruno, you know the house you sold me, the tenant's not paying, what can I do? Right? Then I can say, hey, here's my landlord tenant attorney. By the way, he will advise you, but by the way, eviction and recovery of monies are two separate lawsuits. I let them know right away. It's two separate things. All right. That's what will make you different than other realtors, giving out information even when they don't ask for it. Okay. If you know something, say something. Okay. Now, the landlord can treat the tenant as sufferance by either objecting to the tenant holdover or informing the tenant of such treatment, thus creating a month-to-month or periodic tenancy. The landlord receives rent, and both parties have to provide notice within a certain period of terminating the arrangement. Third option, the landlord can treat the tenant as a trespasser and proceed with an eviction and damage action. Eviction and damages action, two separate actions, like I said. Under this situation, the landlord must comply with the notice to quit requirements in the lease, as well as state law regarding landlord-tenant relationship. Like I said, each state is different when you're trying to kick somebody out. Ashley's asking, so if you declined the little bit of money she gave you, that would have helped. Of course. I should have suffered. Absolutely. I should have said, no, I don't want your money. I want you either the whole money or get out. Because when you accept some money, you've made a settlement. You agreed to something. That's how the judge told me. You agreed to something. So suffer, get him out. Yep, all or none. There you go. Elizabeth says, hate Jersey and their squatter rights. Try to do this in New York. Steven's not here, otherwise he would tell you. In New York, see here, we can get somebody evicted. Well, not now because of the whole COVID mess and whatever. But my attorney, in less than 45 days, you're out. My properties are in Jersey, in Newark anyway, but so it's just that court that I deal with, right? But 45 days, you're out. In fact, I have the procedure so well established that you're supposed to pay until one date. And by the way, we're going to cover all this stuff. You're supposed to pay by one date, let's say the 5th. By the 6th, my attorney's sending you a letter. Say, hey, you defaulted. We're about to go to court. Now you owe, and guys, I'm not a monster. I'll explain better in a second. Now you owe the rent, the late fee, and the attorney fee for this letter. If you want to prevent court fees as well, please contact me now. That's it. Boom, right away, notifications to everybody. The very next day. I don't wait until the 8th to figure out, till the 10th to figure out. So this used to happen. I used to make these mistakes. The first tenant, I told you, 9 months without paying. She would pay in installments, like 2-3 month installments, pay something. Right? I had a tenant that I was charging him late fees. And he's like, you charge me late fees, so I pay whenever. He would start by paying on the 8th. Then a couple months later, he started paying on the 15th. A couple months later, he's already paying me on the 23rd. So now I went 23 days without getting the rent payment. Guess what happens to my mortgage? They're not getting paid either. So I told him, listen, there's a late fee. Well, yeah, but I'm paying the late fee, aren't I? I'm like, what? Just because you pay the late fee doesn't entitle you to just delay this till the next month. He goes like, Bruno, I'll make that in the weekend. I'm a promoter. We will do it. I have an event coming up at the club, whatever, on this weekend. I'll give you the full money. That's not how this works. It's not when you can pay me. It's when we agreed that you would pay me, which is every month. So I changed my procedures and my late fees to include immediately attorney notification, and I charge a percentage for every day that goes by. Starts with this $100 late fee, and then there's a percentage every single day that goes by. Look, you're not going to take advantage of me. Now, if you got problems, that's why I said I'm not a monster. I've helped a lot of people. If you have problems, let me know. But talk to me. Talk to me. This is the thing that annoys me about lending money and stuff like that. I have a good friend of mine called me last year after the flood. Oh, my car got flooded, please. Is there any way you can help me? As soon as I got back from Portugal, like a week later, I go straight, the day after I came back, I go straight to the bank, gave him a cashier's check, $8,000, go ahead. Right? This was after the flooding. So last year, 1 year now. So far, he paid me $3,000. He says, I only need it for 2 weeks because the insurance claim and this and that, I'm going to get the money and pay back. I got no problem with it being a year later. Here's where I got the problem. And I do the same with tenants. And I tell everybody, this is a business. Owning real estate, this is why I'm trying to change your mindset here for being a property owner, is a business. So I told him, look, you're a good friend of mine. If you got problems, let me know. Don't ignore me. The radio silence, I hate it. Because it makes me feel like you're doing it on purpose. And then when I see you, by the way, this is true with my tenants too. When I see you clubbing, or when I see you going out to a baseball game, or when I see you going out fishing, you got the time to do that? You got the time to make money to pay me. Go figure it out. Because when I owe money to somebody, I work 24/7 nonstop. I'm making my money so I can pay you back. Right? Don't go like, oh, Bruno got money, we're good. No. You guys understand? I learned 17 years ago that this is a business. And as the years go, I'm learning more and more that you have to treat home ownership, landlordship as a business. Okay? Remember that. I had an Airbnb, same thing. Just recent. Like Airbnb calls me, said, hey, Bruno, the guy cannot come in. So he wants his money back. I'm like, he was supposed to check in 3 days ago. Like, I can't give him money back. What am I going to do now? I give him money back, and where's my next tenant? Where's my money coming from? This Airbnb thing is a business, right? Oh, Bruno, we know, we understand, and you do have the cancellation policy up front and this and that, so they know. I'm like, okay, so this is what I'm willing to do, because I'm not a bad guy, but you have to be fair, right? Here's what I'm willing to do. I will refund the money up to the date of the claim. They went back and forth, back and forth. A week goes by. So I gave him money minus 1 week. Luckily, I only went like 4 days without getting it rented again. Like 4 days, that's it. Luckily, because one of my properties is in high demand. So if you go see it, it even says there, oh, you're in luck. Usually there's no space here. But it's a business, guys. This is a business. You have to treat everything you do seriously. Okay? So yes, all or nothing. Don't accept a little bit of money because that makes an agreement, a settlement, that you will take any money, just keep going. All right, Zoraida, if you would have accepted an agreement with the amount and you said you have 30 days to pay the rest, see, but that's what I'm trying to say. You gotta settle somehow. So you have to, like, what I do now is my attorney sends that letter. And if they, immediately it's a legal letter. If they say, Zoraida, that oh, I only have like $500, the attorney will write in legal terms that we accept your 500, but the rest is due by whatever date, or straight to court. If you don't pay us by this date, see, the attorney doesn't even notify me. Straight to court. Do you see what I'm saying? So everything, yeah, Lacey, put it in writing. That's what I'm saying. Everything in writing. Okay. All right. Lease agreements. Most states have no special wording to establish the landlord-tenant relationship. A lease may be written, oral, or implied, depending on the circumstances and the statute of fraud requirements. What are the requirements for a valid lease? A lease is a contract, right? I said that before. Okay, so what are the requirements for a valid lease? Let's start with those. Contract for a contract is the same as a valid requirements for a lease, which is called consideration, legal purpose. What is it? Offer and acceptance or meeting of the minds, yes. Parties. Ooh, ooh. Yeah, parties, people, yes. Party people. Come on, guys. What else? We have consideration, we have offer and acceptance, we have legal purpose, competent parties. That means we're adults and of sound mind. Very good. So for a valid lease, same thing. The parties must be legally able to enter into an agreement, meaning certain age, sanity, and other requirements that we just went over. The lease must include a property description. Look, if I have a building with 100 units, you need to know which unit you're occupying, right? It's the same thing as going to a hotel. You got suite 101. Great. You don't want somebody else to rent suite 101 as well, right? So which one are you describing? Exclusive possession. Do you guys remember that I said you have possession of the property, right? And use of the property, right? Very important. Those are the rights transferred to you. Okay. Consideration, offer and acceptance, and signatures. Now, are signatures required? Are signatures required to make a valid contract?
Yes.
I got 3 yeses, I got 1 no. Are signatures required, Fernando, to make a valid contract? Don't read, guys, because what I'm asking has nothing to do with what's there right now.
Yes.
Signatures are required. I'm getting some no's. I'm going to say yeses.
No, because we have an oral contract.
Thank you. No, because you can have an oral contract. Where are you going to sign if you have a verbal contract? Where are you going to sign? Okay, so signature is not a requirement, but if you do have it in writing, then obviously the signature has to be there. So the landlord must sign the lease to convey the leasehold interest. A tenant doesn't need to sign, although it's prudent to do so in order to enforce the terms of the lease. Multiple tenants who sign a single lease are jointly and severally responsible for fulfilling the lease obligations. You guys know what this means? It means that if there's 4 of us renting this apartment, we're jointly liable, all 4. But if only one of us has money, I'm severally cut from everybody else. Remember the word severalty? Cut from everybody else. I'm solely responsible for it. So if I'm the one with money and I rent an apartment with my broke friends, guess what's going to happen? Some of you are laughing. Some of you are probably like, oh, yeah, I got broke friends. What's the problem? There's no problem. We're just talking about contracts. I also have broke friends. I used to be the broke friend. Okay, so I've been there, done that several times. Okay, what I'm trying to show you is that when you sign a lease or a contract, we're all liable for it. All of us, jointly and independently. Okay, so if my friends cannot afford, I'm gonna have to pay for it. So choose carefully before getting into a contract. Okay. Thus, if one renter abandons of the apartment, the other renters remain liable for the rent. All right, we talked about oral or written. You guys know if it's a lease that's for a period extending 1 year, it cannot be oral. This is in general. State of New Jersey, it's actually 3 years. So you can go up to 3 years on the verbal lease. That's ridiculous. Jersey usually has like the strictest laws. But when it comes to this, oh, a verbal lease for 2.5 years, no problem. Just count on somebody's word. You got it. Anyway. We will talk about statute of frauds. If you have clear and convincing evidence, you can enforce it. Okay, so eyewitnesses, something in writing that shows the intent, even though it's not an actual contract, if we have something that shows that was the intention of the parties, it could be enforced. But each state has their own statute of frauds. Lease clauses. Emily, would you have to record them? From state to state, the recording rules change, so it might not be admissible in court. So got to know whether it is or not. If you do record, make sure you get their permission, even though 90% of the times in Jersey is not required, only one party notification. Lease clauses. The clauses of a lease define the contractual relationship between the landlord and the tenant. And the most important and basic clauses are the following: rent and security deposit. I mean, how much you're going to pay rent, how much you got to pay up front before you rent, right? Now, a rent clause stipulates the time, place, and manner. So how you're going to make the payment. Some say cash, some say check, some say direct deposit, some say mail it, some say I'll come pick it up. So you have to say how this is going to happen. It defines a grace period if it's allowed, and states the penalties for delinquency. We talked about it already. And it's not mandatory, but a lease may define a security deposit. Did you guys know that? Security deposits on leases are not mandatory? Yeah, I can rent to you and not ask for a deposit. It's just like the contract for purchase. It's a good faith security deposit. Okay, we give the security deposit to show that, hey, we're not going to destroy the property because I know you're going to keep my money. So instead of you keeping my money, right, I'm going to maintain the property. That's the exchange. Same as when you purchase a property, you give the good faith deposits to show that you will purchase the house, right? So it's not mandatory, but every state law regulates the handling of the security deposit, where it is deposited, and whether the tenant receives the interest on the deposit or not. A landlord may require additional financial security from the tenant of dubious creditworthiness in the form of personal guarantees, third-party guarantees, or pledges for property as collateral. So a cosigner, usually it's what happens. We don't go like, I'll rent to you if you give me your car. No, we don't do that, but there are options. Okay. Also, like I said, state law defines how much security deposit. In Jersey, we can only ask for 1.5 months security deposit up front. Okay, that's the max we can charge up front, right? And I'll explain that when we get to the state. I'm just letting you know from state to state that deposit is different. I think New York, it can go up to 3 months of upfront deposit, where Jersey is 1.5 months. Lease term. In absence of explicit term with a beginning and ending date, a court will generally construe that the lease to be a tenancy at will, cancelable upon proper notice. Repairs and maintenance. The lease has to state who does the repairs and the maintenance, right? Did you guys know that the tenants are responsible for part of the maintenance? Did you know that? For instance, changing a light bulb. You're gonna call your landlord because of a light bulb? No, right? So generally, a tenant is responsible for routine maintenance of the premises, while the landlord is responsible for general repairs. In residential leases, the landlord is responsible for major repairs and capital improvements, and payment of repairs and maintenance costs are, however, entirely negotiated between landlord and tenant. Like most of my leases say that up to a certain amount, it's on you. And the responsibility that you have is, for instance, changing light bulbs, changing the air conditioned filter. If you put the cheap one and you get sick, that's your problem, right? I put that on you because there are filters that filter all the allergens or most of the allergens and so on. But that's you. I don't go there and replace it. I leave it on up to you to do so, right? And a few other things that are listed as tenant repairs. Above a certain amount, and of course depends on the property that I have, above a certain amount, I take over. Okay. Subletting and assignment. I'm sure you guys are familiar with these words, subletting or subleasing, right? Is it the transfer by a tenant, which is the sublessor, of a portion? Remember this, subleasing is a portion of the leasehold interest to another party, the sublessee, through execution of a sublease. So what we're saying is, I rented a 3-bedroom, and now I bring roommates. These people are not on the lease. I got them after. Okay, if I stop paying the rent, what happens? If I stop paying the rent, what happens? I'm the one that rented the 3-bedroom. If I stop paying the rent, what happens? I get evicted. And because they're not parties to the contract, they have to get out too, right? Okay. Now, what if they stop paying the rent? What if my roommates, the ones I sublease to, what if they stop paying the rent? Can I go to the landlord and say, hey, I can't afford because they didn't pay me?
No, it's still your responsibility.
It's still my responsibility. So this, guys, is the challenge. This is the challenge with subleasing, okay? The sublessor remains primarily liable for the original lease, okay? Sublessor remains primarily liable for the original lease, okay? Now, an assignment, you guys remember this word? We covered it yesterday on the contracts. Assignment, okay? An assignment is the transfer of the entire leasehold interest. Zoraida is asking, you can put not, can I prohibit my tenants from subleasing? Is that what you're asking? Okay. Actually, most leasing contracts do state no assignment or subleasing without the landlord's written permission. That means, all right, if you want to rent rooms to other people, you need to reach out to me and say, hey, Bruno, whatever situation, I need to rent rooms to somebody else. Okay. And if I allow, go ahead and do it. Just make sure to protect your interest. You ask me to put it in writing that I allowed you to do so. You got it? Okay. So assignment, we transfer the entire leasehold. So I'm not renting a room. I'm saying, hey, I'm done with this apartment. Do you want to take over? Right? So I get Shakira to take over my apartment, for instance, a 3-bedroom. Shakira, I'm going to get you to rent the whole thing. I'm out. I'm moving somewhere else. You still got like 7 months left on the lease. All right. Here's the thing. I want to make sure you guys remember the assignments yesterday, contracts, right? If Shakira does not pay the rent, what happens?
You're still,
She gets evicted, right?
Yeah.
Okay. What else?
The original person is responsible. Like they're liable.
The original person is responsible?
You.
The assignor?
Yes,
What about Shakira?
she's also.
Okay, so the original person is not responsible. Both of us
They're both.
are. Okay, you got to be very clear about that because the responsibility is not me if she doesn't pay the rent. That would be a sublease. But if it's an assignment, the whole thing, we're both liable. The assignee becomes primarily liable, and the assignor, the original tenant, becomes secondary liable. So both of us are getting sued, Shakira. What are we gonna do? All right, sucks. Okay. So like I was saying before, Ashley, all leases, I'm sorry, Zoraida, all leases clarify the rights and restrictions of the tenant regarding subleasing and assigning on the leasehold. Generally, the landlord cannot prohibit either act, but the tenant must obtain the landlord's written approval. Okay, so I have to have something in writing. The reason for this requirement is that the landlord has a financial stake in the creditworthiness of every prospective tenant. So I just want to make sure who they are so we can address them. Okay. Rules and regulations. Obviously, the tenant must abide by all rules and regulations set in the lease. Improvements and alterations. Can a tenant change my property? It depends on the agreements we got. Okay. So a landlord typically wants to prevent the tenant from making alterations that later tenants may not desire. By the same token, a tenant who pays for an improvement wants to know who will own it at the end of the lease term. This is very important. Okay. Improvements and alteration clause, therefore, identifies necessary permissions and procedures and who owns the improvements. Customarily, tenant improvements become the property of the landlord in absence of an express agreement to the contrary. So, you want to make changes to my property? Go ahead. No problem. If I don't have anything in writing on how you're allowed or what authority you have to make these changes and what's going to happen at the end before your lease ends, right? Then technically everything you do is mine. I'll give you an example. I'll tell you, I got stories for days. I had a tenant that decided to repaint. I'm like, great, no problem. Also decided to give me a new backsplash in the kitchen and a new countertop in the kitchen, and replaced also the appliances because they wanted stainless steel, not the white ones. So, new stove, new dishwasher, new fridge. Okay. What happens to those items that were installed? To the backsplash, the countertop, and these appliances that were purchased? What happens? They're mine. The question is, do I have to pay them? Do I have to compensate them for what they did? A brand new backsplash and a brand new countertop in my kitchen. The guy even did the whole treatment of the tile and everything.
No, you don't compensate because you didn't ask.
You didn't ask permission. Louis, deduct from the rent. Nobody asked me permission.
What if you didn't want all of
Here's what I told him. There's a lot more to this story, but I'm just summarizing. The guy even moved there without my permission. The previous guy that owed me money transferred the lease to him. But whatever. I allowed it because I saw the family in need and I'm like, sure, no problem. But then all of a sudden, this guy is, like I said, painting, backsplash, and like he's showing me all proud. Look, Bruno, what I did. Look what I did. And I'm like, I appreciate it. I don't know what do you want me to tell you. Looks nice. Oh, it was like, this was like $500 and this was like, I'm like, cool. So you're not gonna, I'm like, I don't have to. That's not how it works. You're improving my property. Do you want to move to the first floor and do the same? This is literally what I told him. You want to like switch, you know? But I told her I'm not a monster, right? So I did give him credit for everything. I just asked him for the old appliances. Where were they? Because if I don't have the old appliances, then those stay. That's it. So we put something in writing. We did. I promised to give him a discount on the rent for like 6 or 7 months. This person saw me earlier this year. I was having a drink with one of the mortgage guys, and we're going over business, right? And this guy sees me from across the room, kicks everybody out the way, comes towards me, gives me the biggest hug ever. And I'm like, weird. It was like, because of you, my life changed. I'm like, okay,
What I do?
what did I do? Yes. So what happened was, when he was doing his immigration paperwork, he asked me for some stuff. And I helped out. Okay, so some paperwork that he needed, but I didn't even know. Like the years go by, and I'm like, I completely forgot about it. Sees me, and that's it. I now have I'm a green card holder because of you. Okay, see, and I'm like, and I was able to sell my property for $30,000 more because of you. See the exchange? That kitchen, just that new countertop, backsplash, and new appliances. Whew, 30K more. He paid like not even $1,000, I think, for everything. Yeah. Right, Shanice? I try to be. You know me. All right, options. You guys already know what these are. Option to renew, option to purchase, and so on. The tenant does not have to do it, but the landlord has to abide by it if they do. Damage and destruction. What happens if you destroy the property or if I destroy the property? What happens to the lease? Lease. Let's start with the lease.
Happens if you destroy the property.
If you, the tenant, destroy, or if I, the landlord, destroy, what happens to the lease? Automatically ends. Destruction of the property automatically ends the lease. Okay? Now, what about liability now? Okay, so it says right here that state laws regulate these provisions. Liability is based on state laws and also our agreement according to state laws. So yeah, Lacey, it terminates. I have to I keep your security deposit if you, the tenant, did it. But if I, the landlord, did it, you might also be able to go after compensation because now you're being relocated because of something I did. Okay. All right, lease types. There's different lease types. We have gross lease, we have net lease, percentage lease. These are the three main ones. And there's a few other leases. There's graduated leases, there's variable leases, oil leases, and so on. Gross lease. Gross lease is all inclusive. Gross lease is all inclusive. What does that mean? It means that the tenant pays $1,500 a month and that's it. The landlord is responsible for taxes, insurance, maintenance, and all that stuff. They don't share the liability. Okay. So gross lease, your rent is all inclusive. You don't have to worry about anything except, of course, utilities. That's on you, right? We're good. Gross lease is the easiest one. Now, what is the difference between gross and net? If you have a paycheck, you know the difference, right? Gross is what you wish you take home. Net is like, huh, okay, this is what I got, right? It's after the, are you okay there? It's after deductions, right? So a net lease actually transfers the liability to you. A net lease provides that in addition to rent, the tenant pays some or all of the property charges. Okay. Why is it net? Because it's rent plus property charges. Rent plus property charges. All right. So in this building where I'm at right now, you guys are home. Most of you don't know because you haven't been here. Some of you already know. But in this building, we're on the third floor. We occupy roughly, I think it's 4,000 square feet, something like that.
Okay.
Right? We have a net lease. That's what I was trying to explain. We have a net lease. We pay a flat fee on the rental, but then we pay a portion of the taxes. So this has like 90,000 square feet, something like that. So you divide the 4,000 square feet we have, or a little bit over than that, divide that by the 90,000. And then that percentage is what we pay in taxes, insurance, and CAM, common area maintenance. Okay. So it's a net lease because we pay a flat fee plus shared expenses to maintain the building. This is usually, so gross leases are usually for residentials. Net leases are usually for commercial industrial buildings. If you ever hear the term triple net lease, so when you look at the lease, it says NNN, triple net, that means it's net taxes, net insurance, and net for all other expenses. Very important, except debt services. So we're talking about mortgage. You're not paying my mortgage, because if you're paying everything and my mortgage, might as well be the property owner, right? So you're not paying my mortgage. You guys good so far? Give me a thumbs up. Yep, awesome. Have you heard all these terms before? Gross lease, net lease, triple net lease. Okay. What about percentage lease? What do you guys feel about this one? My gross lease, all inclusive, net lease, there's deductions, obviously. Percentage lease. What do you guys think? Without reading.
You pay a percentage.
Say it louder.
You pay a percentage.
You pay a percentage of what? Isn't that the net lease? Flat fee plus percentage of the charges? Where's the percentage lease? Usually you'll find these. Yep. You find these in the retail business. So for instance, if I have a mall, right? Shopping center, something like that. If I have that and I rent units there, usually as a landlord, I'll ask you for rent and a percentage of your business income. So it's like we become partners. So percentage lease provides, based on business profits, you get a percentage income. Can the option to buy be attached to all of these types? Yeah, that's by agreement. It's totally separate on Jefferson. Great question, but it's totally separate. Okay, option is a lease clause. Here we're talking about types of leases. So all the lease clauses could be in any of these leases. Okay. So, all right, Connie, no problem. So a percentage lease provides that the rental be based on a percentage of the gross income received by the tenant doing business on the leased property. So percentage of gross income, not net income. Now, this type of lease is most commonly found in shopping malls. The percentage lease usually provides for a minimum fixed rental fee plus a percentage of that portion of the tenant's business income that exceeds the stated minimum. For example, a lease might provide for a minimum monthly rental of $1,200 with the further agreement that the tenant pays an additional amount each month equivalent to 5% of all gross sales in excess of $30,000. So every time the business goes above $30,000 that month, I get 5% of the gross receipts above that amount. So what these shopping malls do is they bet on your business. They charge you a lower rent than what the fair rent would be, right? And then, hey, if your business does well, I do well. If your business goes down, at least the stated minimum, that's what you got paying me, the $1,200. Does that make sense? All right. But there's other lease types. We talked about variable leases, ground leases, oil and gas leases, lease purchase, and sale and lease back. We're going to cover these and then take a quick break, okay? Some people need caffeine. So, didn't we warn her to get it before class started?
I know that I'm gonna need it after I'm here.
Nashua, give me just 4 minutes if you can. And then I'll let you go. Squeeze. So variable leases, there's a graduated lease, which provides for increases in rent. So we say, hey, you started at 1,000, 6 months from now, you're going to go to 1,200. 6 months later, you're going to go to 1,400 until it reaches the actual leased amount. And then there's the index lease, which allows rent to be increased or decreased based on changes of the government CLI or cost of living index. So let's look at inflation. Inflation is going up always, right? So what happens to your lease? It's always going up. Ground leases are also known as land leases. And this is where you just rent land. Ground leases or land leases. You just rent land. And guys, stay with me, please. If I rent just land, what are you going to do? Can you do anything with the property? Yeah, you can. Whatever we agree to. Maybe using that land to do parking spaces. Maybe you build on it. Exactly. Right? So the lease will determine what you can do with it. The problem is at the end of the lease, can you keep it? It depends. Can you do you have to tear it down? Do you have the option to buy? Do you have to find a suitable tenant? Right? These are all options. All right. But a ground lease is you're renting the land and then you can either work on it, build it, develop it, whatever. Everything goes back to the lease. So whatever the lease says. So let's say you're going to build, I give you land, like 10 acres, and you build a shopping plaza. This is going to be a 1-year lease, right?
How are you gonna build a shopping center?
Listen. And why would you have a 1-year lease if you're going to spend millions of dollars on it? Usually they run for terms of 50 years or longer. It could even be 1,000 years if you want. Because you are, yeah, that's for like big companies usually do this. Banks do this. Like Walmart does not own land. They lease all the land.
Why not buy it?
Huh?
Why not buy it?
Because a lease is an expense. It's a write-off.
Write-offs.
Uh-huh.
That's all
Where if
tax.
you buy it is an asset. Uh-huh. Why not buy it? Banks don't buy it. Right? Gas stations. All right, oil and gas leases. Lease purchase is the lease with the option to buy. You guys already know this. What about sale and lease back? Sale and lease back. I sell to you, but then I rent it back from you. Why would I do that? See, a lease back allows the owner occupant of a property to sell it to an investor landlord while continuing to occupy the property. The seller becomes a lessee of the property while the purchaser becomes a lessor. This transaction allows a seller to remain the occupant of the property while transferring ownership of an asset to an investor. The purchaser, meanwhile, is buying the property with a long-term tenant already in place, so it's suitable, right? So there's two advantages to this. On a sale leaseback, I sell to you, maybe I have equity in the property and I need money to continue my business. Where can I get the money? I sell the property. But my business has been here for 20 years. Moving and all that, the expense just doesn't make any sense. So I'm going to sell to you, right? So Connie, I'm going to sell to you and say, Connie, not only am I selling to you, I'll be your tenant for the next 20 years. Like for an investor, I don't have to look for a tenant and they've been here and they're about to get a bunch of money that they're about to give right back to me. Hell yeah, right? So for me, I get working capital. I can improve my material, like the either hardware. So if it's a factory and I need new machines, or maybe I can pay for marketing, or maybe I can get more employees or pay better to my employees. And for Connie, guaranteed tenant. Does that make sense?